All right, just, we're waiting for for our solicitor to come back and sit with us. Then I'll bang my gavel. All right, welcome to Township of Lower Makefield Zoning Hearing Board for January 6, 2026. We have multiple things on the agenda. We have to vote on the executive board, for the board, and the appointment of the solicitor, appointment of court reporter, and then we'll get to the 5 different matters on the agenda. All right.
I'll take over.
Yes,
All
go
right,
ahead.
so I will now call for nominations for chair.
I would nominate Jim for chair.
Nomination for Jim. Any other nominations? Hearing none, I will close the nominations. All those in favor of Jim Doherty as chair, say aye.
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 Any opposed? Abstentions? Congratulations, the floor is yours.
All right, thank you. You want to run the rest of the seats? Or you want me to run the
No,
rest of the seats?
you can
Okay,
call for vice chair.
so can we have a nomination for our vice chair?
Christian Swartz.
I'll second that. All those in favor? Oh, are there any other nominations? Hearing none, all those in favor?
Aye.
Aye. And lastly, can I have a nomination for our board secretary?
Mike McVan.
I'll second that. Any other nominations? All those in favor?
Aye.
Aye.
All right, so we have reorged the board for 1 year, and we'll take this vote a year from now. Okay. We're now going to appoint our solicitor. Can I have a nomination for our zoning board solicitor?
Nominate Adam Flager.
Second.
Are there any additional nominations? All those in favor?
Aye.
And we need to nominate our court reporter.
I nominate Ed McKenna be reappointed as a court reporter.
Is there a second? James?
He did.
Yep, second.
Any other nominees? All those in favor?
Aye.
Aye. All right. Now on to the fun stuff. Okay, before we call appeals up, we have 2 that have requested continuances on our agenda, so 2 of the 5. So Appeal Z25-47 has requested a continuance to February 17th. Someone like to make a motion?
So moved.
Does anyone second?
Second.
Before we have discussion, is there any public comment in the room? Did anyone here show up for Appeal Z25-47? What number is that on the agenda? That would be number 8.
It's Lisanti / ASPDEN.
All right, discussion? No discussion? All those in favor?
Aye.
Aye.
So moved.
Aye.
Then there's Appeal Z25-48, FELIZ von Spreckelsen. They have requested their appeal to be continued to February 17th. Can I have a motion?
So moved.
Second?
Second.
Second.
Any public comment in the room regarding this appeal? All those, discussion? No discussion? All those in favor?
Aye.
Aye. So moved. Okay. First up, please come forward. Appeal Z-25-45, Miller/Lou. You're going to need to speak in the microphones when you come forward, and you can share a microphone, and Ed will share his. First, he's going to swear you in, and then we'll read the exhibits into the record before we turn the show over to you.
Would you each please state and spell your full name?
Tracy Miller, Tracy Miller.
KESWICK, last name LIU.
Ma'am, is your microphone on?
Would you press the button on the bottom of the Thank you. Do you both solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, we have the application as A1, site plans as A2, B1, proof of publication, B2, proof of posting, and B3, notice to the neighbors.
Okay, the floor is yours.
Thank you. The Lews would like to put an addition on the rear of their house, as is indicated on the drawings. They do not have a first-floor bedroom, and that addition would provide for a first-floor bedroom in order to deal with some mobility issues because of some health stuff that's going on. The addition does cause the impervious cover to exceed the allowable 18%. So we are proposing to do a infiltration trench to take the effective impervious surface back to the required 18%.
Okay, board, questions?
So I'm curious, it looks like there's an existing porch that the addition is going to be on the other side of. Is there, is that an exterior porch, or
It is,
is that going to be now enclosed?
yes.
Okay. Don't think that makes any difference, but
So Dan, did you check the specs on the infiltration trench?
Yes, the 3 by 6 by 31-foot infiltration trench will bring it back to the effective 18%.
Okay, great.
I would like to add that when we see plans that are asking for impervious surface to go over and be adjusted afterwards, it helps to have some grading numbers on the
Okay.
plans, showing the which way the ground slopes.
Okay. In this
I understand
case-
it backs up to a lake and everything
Right.
slopes to the lake,
Right,
but that's not the case on everybody's property. so-
agreed.
Are you tying any of the rain leaders into the infiltration trench?
Yes, anything that we can get there with from the back of the house, and definitely the new addition would go into that. And that would also drain the back of the garage, the existing garage roof.
Okay. Board, any additional questions?
No, I mean, the rest of the package seems comprehensive, and providing a view of the building certainly helps too.
There you go. You got the rare compliment from Pete Solar. Nah, that's not true. Pete's pretty generous with compliments. Is there any public comment in the room? All right. Would someone like to make a motion?
Make a motion to approve Appeal Z-25-45, subject to stormwater mitigation back to 18% and approval of the township engineer.
Second.
Discussion. No discussion. All those in favor?
Aye.
Aye. All those opposed? Okay. The ayes have it. Motion carried.
Thank you.
You're welcome. Thank you.
Thank you.
James, are you there?
Yeah, I'm here.
Okay, yeah, Adam and I are having just a little trouble hearing you. I think it's just a little spotty in and out, maybe.
Okay. I keep going muted and then unmuted. Maybe that's part of it.
Oh, okay.
But you can hear me okay right now?
Hear you perfect.
Yep.
Yeah,
Okay.
sounds good.
All right.
All right.
I'll put it on mute.
Next up on the agenda is Appeal Z 25-46, RENNEISEN/OMEARA. Please come forward and be sworn in.
Whoever's going to testify, would you please state and spell your full name?
My name is Jeff Renneisen, JEFF,
Kevin O'Meara, KEVIN, O apostrophe, M as in Michael, EARA.
Margaret O'Meara, MARGARET, O apostrophe MEARA.
Do you all solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right, we have the application as A1, the two-sheet site plan is A2, B1, proof of publication, B1, proof of publication, B2, proof of posting, and B3, notice to the neighbors.
Okay, you folks have the floor.
Thank you. So Mr. Mayor are proposing a new in-ground concrete swimming pool with a flagstone patio around it. And to offset the overage of impervious coverage, we are proposing a stormwater management system, which will cover, the total impervious coverage is 7,205 square feet. The system has been designed to cover all of that, plus an additional 100 square feet. And as a note, the property has an existing stormwater management system installed that was installed back in 2019. So all that's been taken into consideration and is summarized in the stormwater management report.
Okay. Questions, board?
What percentage do you hope to achieve with your stormwater management when you're finished?
I'm based on my understanding, to bring it back to the maximum allowable, so the percentage, let's see here. I don't know if I have that exact number in front of me right now for the
It's 21% is what's allowable.
21.
But he's bringing it back an additional 100.
No, I was bringing it back. You're accounting for all of your added impervious, which
Correct.
is the code requirement.
But is my understanding that you're taking it below what's required? Yes?
Yeah.
Yes,
By 100,
100 square feet.
And there's also existing stormwater
Right.
mitigation, so the effective right now is already lower.
no, I'm aware of that, but maybe, is it possible to figure out what the exact effective's going to be so that when we make a motion, we have that exact number in there? I know we don't need it, but it might be a little cleaner. Does that make sense? Because the effective's not going to be 21, it's going to be.
No, I think we don't do that. I think we actually use the language they have, which is that they're going to mitigate for all the impervious that they're adding plus 100 additional square feet.
Okay. Any additional
Question.
questions?
Yeah, is there, in installing the pool, are you removing any trees?
No.
No.
Easy question.
In addition to the pool, it says that there's a proposed equipment pad.
Correct.
Is that included in the calculation?
Yes, it is.
Any additional questions from the board? Maureen, you're not participating in this matter?
Not participating, but do have a quick question, both for this and the previous applicant. Dan, can you confirm that there's an O&M agreement that is entered into between the homeowner and the township?
Not that I'm aware of.
No? So how are we ensured that the systems are.
I'm not sure. I mean, I could look at when the permit was done for the infiltration trench in question, but I'm not aware of an O&M agreement.
But moving forward, for if permits issued for this pool,
We could do an O&M agreement.
okay,
Yeah.
that would be the preference.
Okay.
Is that being looked for as a condition of the variance, or is that policy?
Is that it permitting?
Yeah.
It's policy in accordance with township.
Okay, so we don't need to conclude that then.
No, I just wanted to clarify that it
Okay.
would be issued
Okay,
and entered into.
so it will not be part of our decision.
No, it's already a condition of.
Perfect. All right, is there any public comment in the room? Is there any public comment online? Nope, lights off.
No, no.
All right, would someone like to make a motion?
Motion to approve Appeal Z 25-46 as presented with the effective impervious
No.
surface.
Not effective impervious surface to mitigate all of the additional impervious coverage plus an additional 100 square feet.
What he said.
To the approval of the township engineer.
Just,
He's going to second it now.
no, just do it one more time.
Yeah,
so
let's
it's
do it
clear
again
on the
so it's
record.
clean.
Motion to approve Appeal Z 2546 as presented with the mitigation to 21%.
Nope.
Oh,
I knew you were stepping in it. This had Pete's name written all over it.
Pete, just give it a go for me, will you?
Make a motion to approve Appeal Z. Make a motion to approve Appeal Z 25-46 as presented with mitigation being provided for all the additional impervious coverage plus an additional 100 square feet, subject to the approval of the township engineer.
Seconded.
Discussion. Christian, by the way, you're a brave man going for that right there. Just so everybody knows that Christian didn't trip all over himself there. This is different than how we normally do it. We normally do it how Christian wanted to do it. All right. All those in favor?
Aye.
Aye.
All right. The ayes have it. Good luck with your project.
Thank you.
Chairman, members of the board, thank you very much.
Maureen, what's your level of participation for our last appeal tonight?
Yeah.
Coming before us, yeah.
The township has sent us to oppose this application.
Okay, thank you.
Thank you.
Probably should have.
The township has sent me on behalf of the township to oppose this application.
By the way, the appeal that just came forward was Appeal Z 25-44, McGinnis JMAC Investments. That is the appeal that Ms. Carlton is referencing. She has been sent by the township to oppose this appeal. Okay, Ed, please swear him in.
Would everybody please state and spell their full names?
James McCafferty, McCafferty spelled McCafferty.
Vince Fioravante, F as in Frank, I-O-R-A, V as in Victor, A-N-T-I.
Vince, you're going to need to do that over again because you didn't have the microphone in front of you.
Vince Fioravante, F-I-O-R-A-V-A-N-T-I.
Do you both solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
I do.
Okay,
Let me mark.
yes, you got to mark the exhibits.
Yeah, we're going to do the application as A1. We're going to do the zoning exhibit site plan as A2. We will do, which has the colored-in property in the middle of the page, the zoning exhibit site plan as A3 without it colored in. We will have A4, was that smaller lots? SM?
No.
Oh, similar lots?
No,
I'm sorry.
I think-
A little close together. Zoning exhibit similar lots will be, what are we up to, A4?
That was A4, yep.
A4. We will have the the depictions of what the home would look like as A5. Next one, the permit plan erosion control as A6. The final lot plans will be next, and that'll be A7. A8 will be tributary, it has a lot of the grading and things of that sort. It's A8. A9, it's going to be the aerial. A10 will be the existing features plan. And then A11 is the permit plan erosion control plan, sheet 1 of 2. And last sheet.
Tax map.
Yeah, is that a tax map? Mike? Is that?
Subdivision across the street where the utilities.
Okay, and that'll be, what are we up to, A12? And B1, proof of publication, B2, proof of posting, and B3, notice to the neighbors.
All right. Before you start, Mr. McGinnis, I just want to, this property was in front of our board possibly 12 to 20 months ago. Different applicant, different, requesting different levels of relief. I'm saying that because currently we have 2 of us board members who participated in that matter and 3 board members voting tonight who weren't present that night. So at some point, I was hoping either Mr. McGinnis or Mr. Fioravani could explain the differences between what was requested then and what's being sought tonight, so that the board members who weren't familiar with the prior matter can have a better understanding. That's it. Good luck, guys.
Thank you. Mike McGinnis from Begley Carlin here tonight on behalf of the applicant, which is JMAC Investments. And I guess a good suggestion, I'm going to, just to orient the board, I'll give a little introduction. I'll give a bit of a summary as to how this application differs, and then Vince is going to provide testimony regarding why it differs and how we've arrived at the point that we've arrived at to be back before you this evening for consideration. My client, and is here with me this evening, Jamie McCafferty, is the equitable owner of the subject property. Jamie is a local builder who builds high-quality, predominantly single-family detached dwellings in Bucks County. As Mr. Doherty indicated, at least a couple of you may recall, and some of the members of the audience may recall, that we were in front of you, I think it was all the way back in May of 2023, to discuss the construction of a single-family detached dwelling on this lot, which would have the same square footage in terms of the footprint of what we're proposing this evening. The property is located in fronts on HEACOCK Road. The tax map parcel number is 20-12-18. It's zone R3M, and it's about 0.4 acres gross. Specifically, it's 14,300 square feet. And part of the prior presentation that we made to this board was a discussion regarding the differential analysis between gross acreage and net area on the site because of the right-of-way that exists on HEACOCK Road, which brought the functional net acreage of this site down to about 9,300 square feet of a functional lot size. And then that conversation necessitated the relief that we were seeking at that time, which was similar in terms of the classification, but different in terms of the specifics. And what I mean by that is the application that we filed and presented before this board about 2.5 years ago sought a front yard setback variance to permit an 8.5-foot front yard and a rear yard setback variance to permit a 10-foot rear yard on this site. That would, we presented at the time, permit the construction of a single-family dwelling that would be compliant in other respects on this property. For reasons that Mr. Fioravani will detail in a moment, based upon work that was completed with DOT, we have now remedied the acreage situation for the property aligning the net and gross acreage. So now we have a 14,300 square foot net and gross area. What that has done is it's allowed us to position the home that we're proposing so that our front yard setback legally that we're asking for has expanded up to 18 feet, and the rear yard setback, if this home were to be built, would be 25 foot in terms of the rear yard. So we've taken it from 10 feet to 25 feet. One of the concerns that was expressed, I know, by one of the neighbors, maybe more than one of the neighbors, and I think was voiced by the zoning hearing board when this application or a version of this application was presented previously, was that the compressed rear yard with a 10-foot rear would functionally limit the usage for a future homeowner while also constructing a home which would potentially, like it was described as peering over the rear yard of the homeowner who lived behind this lot. We had discussed, but had admitted, I think at the hearing, some of the site constraints that would make it difficult for a planning to occur along the rear property line while still having a functional rear yard. Our suggestion, and we'll walk through this as part of the testimony, is that the plan that is before the board this evening for consideration is a significant improvement for this property. A 25-foot rear yard would permit planting a row of arborvitaes that would provide natural screening for the site to the rear. There is a very large side yard on the property that would function kind of as a quasi rear yard while still allowing a rear yard in addition to the screening that we believe we can now adequately bring to bear on this property. Additionally, Mr. Fioravanti has already procured the permitting from DOT for the driveway installation that we're discussing with the home orientation. And the only reason that I'm noting that, not that it entitles us to any of the relief that we're seeking this evening in a dispositive manner, but it is relevant because if you look at this application in two areas, one is the front yard and one is the rear yard, we're going to discuss why we think the rear yard setback would be appropriate to procure a variance. But we also, I think, would want to illustrate that permitting a front yard setback of 18 feet would not cause a hazardous condition on this site. And I would suggest that Mr. Fioravanti can detail that the steps that have been taken and the review that has occurred has essentially confirmed DOT's concurrence that a home like this could be built on this site without causing a dangerous condition. So what we're left with essentially is a lot now that meets the acreage requirements in this district. It is greater than the minimum acreage requirements. It would permit an appropriately sized, nice, single-family detached dwelling to be constructed here. It is compliant with the rest of the dimensional performance standards in the district for things like impervious surface coverage and building coverage. And what we're left with for this lot, which was legally created decades ago, is really the only thing that can be reasonably developed here, which is a nice single-family detached dwelling by a home builder in our area who builds nice single-family detached dwellings. And we've undertaken some work in the last 2 years to get this to a point where I think we, again, have significantly improved the situation and the proposal from what was before you previously for consideration. So that's sort of the summary of describing what's different, what we're here to present, and if I could, I would like to offer Mr. Fioravanti to provide greater clarity to this presentation at this time.
Good evening, everyone.
Microphone, Vince.
Do we have all the exhibits all the way through 12 that are available?
Yeah.
Okay.
All right, and Vince, just briefly before I turn the floor over to you, can you please, again, just state your name for the record?
Vince Fioravanti.
Okay, and where are you employed, Mr. Fioravanti?
Fioravanti Incorporated, Southampton.
All right, and you are a licensed PE in the state of Pennsylvania, is that correct?
Yes.
And you've been recognized as an expert in civil engineering throughout the county, including by this zoning hearing board, is that correct?
Yes.
I can go through anything that's necessary with Mr. Fioravanti's credentials, but I would like to offer him as an expert in civil engineering.
Any issue, Ms. Carlton?
None.
Okay, so accepted.
All right. Thanks, Vince. And just to confirm, you and your office have prepared the plan which is before the board for consideration this evening. Is that correct?
Correct.
And you prepared the plan that was before the board previously for consideration, correct?
Yes.
And you testified at that hearing as well?
Correct.
So you would be qualified to testify as to the steps that were taken since the last hearing and what we're here to discuss this evening. Is that right?
Yes.
Okay. Please begin, and then I'll interject and answer, redirecting some questions.
Just overall, as we mentioned, the project on its face is a simple project, proposing one dwelling unit with a footprint of approximately 1,550 square feet on a single vacant lot with a net lot area of 14,300 square feet, which is zoning compliant. We will be requesting some variances tonight, and I think just quickly, to go back in history 40 years, just to show everyone that maybe wasn't here on the first go-around, how we got in this position or how the property became the way it is. If I could go to, I think we labeled A7, the original subdivision. Okay. All right, so if we're looking at parcel A7, our parcel was an original parcel fronting on HEACOCK Road that was cut off and isolated by the development of the Heritage Oaks subdivision 40 years ago in 1986. In fact, the adjacent parcel, 542 HEACOCK Road, was also isolated by the same development, and that parcel has two dwellings on it that are situated in a similar manner to the proposed dwelling on this parcel. If I look at my pointer, you can see the subdivision, you can see our parcel right here. That's not a part of the development. And you can see the adjacent parcel, 542 HEACOCK here, was also not part of this development. So this development was done in 1986. It developed the land all the way around here, and these parcels already existed with frontage on HEACOCK Road. Further, if you were to look, you can see our parcel here, and you can see where the original deed came to what was probably the center line of HEACOCK Road, 50 years ago. And, back at that time, all the properties, as you know, were deeded to the center of the roadways, and the legal right-of-way was established at 16 and a half feet wide from the center. So years go by, and Heritage Oaks is developed, and these two parcels remain the way they were. And we'll get a little bit more into that later. Also, if I go down HEACOCK Road, the next parcel over, it was also something that wasn't developed and existed for a long time. When we look at this again, we'll see that this is a situation where they had frontage on HEACOCK. There was no other place for them to be developed. If we go back to, let's go back to the aerial, which is A9. Okay, so now we're looking at A9, and we can see the parcel. You can see its orientation. Also, if you zoom out just a little bit, I want to show that there's four parcels now, four dwellings, where the front yard setback, the situation is very similar to ours by necessity. We can look at, from left to right, we're looking at the front yard setback that we're requesting, and our point is that it's completely in conformance, in harmony with the surrounding area. Looking from left to right, this dwelling here is about 55 feet from the road. Ours will be about 26 feet from the street. I'm not talking about the right-of-way, just from the street. This one here is about 32 feet, and then the fourth one's about 18 feet. So if I look at those numbers again, 55, 26 is our site, 32, and 18, we're right in the middle of these, it will be four dwellings, and we're right in the middle of all four of them, and our distance to the roadway is right in the middle. It's not the furthest, it's not the closest. It's in harmony with what exists along HEACOCK Road by necessity because of how it was derived originally. Again, when I look at the rear yard setbacks that we're requesting, when I look at the rear yard setback variance we're requesting, I'll state again that I believe it's in harmony with the surrounding area. Look at the buffering we can provide now, but the distance between our house and the nearest house in Heritage Oaks, we estimate that to be about 110 feet. When I look at the rest of the distances in the subdivision, down here in this area, house to house, the rest of the community, ours is larger than most of them, almost all of them. So if I look at our impact on the immediate adjoiner, we're 110 feet away. All the rest of the community here is less than 110 feet. So we're really not having any negative impact on the most, affected property in terms of the rear yard. We now have 25 feet where before we had 10. 25 feet's plenty of space to a double row of evergreens, white pines that easily will block us from a neighbor who's as far away as anybody in the development. So I'd say no impact on the community to the rear. I'd say the front yard setbacks that we're requesting are in harmony with all the houses that are on HEACOCK Road, all the lots that existed back then when Heritage Oaks developed around them. So I think it would look fine there. It would be a nice-looking dwelling. It's not any further from the street than anyone else. Utilities exist across the street. When we talked to PennDOT, we went and we looked at the situation there with, the ultimate right-of-way, 120 feet wide, 60 feet from center on both sides. And what happens, as we all know, with ultimate right-of-ways is they're offered to the authority having jurisdiction, which in this case is PennDOT. PennDOT accepted it. When I look at the PennDOT records for the highway in front of Heritage Oaks, it shows 120 feet. When I looked at the PennDOT right-of-way where our dwelling was, it shows 33 feet. So I investigated with PennDOT, and I said, how can the right-of-way be 33 feet on HEACOCK Road where our house is proposed, when the paving itself is 30 feet from the center? The road's 60 foot wide, and they're saying the right-of-way is only 33. So they went a lot of months of searching records, and there were none. It was just overlooked over the years. And we said, well, we'd like to offer you and formalize the right-of-way of the road in this area. And how much do you want? And PennDOT doesn't want extra right-of-way. It says it just creates a liability for them if somebody gets hurt. Said they never want more than they need. And they agreed to just 5 feet past the curb. So we offered PennDOT 35 feet from the center instead of 60 feet from the center. And a formal agreement and a deed of dedication, they accepted the right-of-way. So now the right-of-way behind our parcel, a lot of these PennDOT roads, the right-of-way varies all the way along. Wherever they need more for widening, they take it. Most of the highways, it says right-of-way varies, and from lot to lot, it goes in and out. Ours does that now, and it's 35 feet half width in front of us, where the ultimate right-of-way was 60 feet.
So if I can, Vince, cut you off and dig into that a little deeper for a second. This lot is, and we discussed this previously, this is an elongated property, correct?
Yes.
It's not deep, it's stretched
It's
along
wide,
HEACOCK.
yes.
Okay. And the relief that we were seeking previously, as you've discussed, was a 10-foot rear yard and about an 8.5-foot front yard setback, correct?
Correct.
And we discussed at the prior hearing how even though it was an 8.5-foot front yard setback, legally, we discussed the distance from the edge of pavement and how that was considerably larger, correct?
Yes.
But we were constrained based upon the ultimate right-of-way and the impact that had on the net versus the gross acreage of this property, correct?
Correct.
And you're saying that through the sequence of events that you just detailed, there is now confirmation that you've been able to, and the property owner's been able to acquire another 25 feet of depth, essentially legally, stretched along the entire frontage of the property. And that's how, when we do the math, we've significantly increased the square footage of the lot by about 5,000 square feet in terms of the net area.
Yes, 25 feet additional depth we got for the property, and 200 feet wide, 5,000 square feet.
Okay. All right. I made a statement or a representation at the beginning that, of course, in addition to front yard and rear yard setback requirements, there's a whole host of other dimensional performance standards that we have to comply with, that anyone has to comply with to develop in our Makefield. And I said that we comply with things like impervious surface and building coverage. Is that a correct statement?
Yes, it's correct, and the lot is compliant with lot area as well.
All right. And you testified as to the plantings that we would be able to maintain along the rear, and it's your understanding that we would be willing to volunteer that as a condition of approval that can be documented with a recorded document with the township having enforceable rights regarding the maintenance of those trees in a manner that was acceptable to Lower Makefield. Is that a correct statement?
Correct.
Okay. I made a statement also as part of the introduction that there was a permit that was in hand with respect to DOT. Can you just give some additional information about that and what you believe that means with respect to any analysis of safety along the frontage?
Yes, it was a detailed procedure with PennDOT to go back and look through the records and the research and to prepare a deed of dedication to PennDOT for the additional right-of-way. And as a part of that, they also wanted us to review the driveway geometry, site distances, and it was all combined into one process. So we do actually have a PennDOT driveway permit. We have a deed of dedication that was recorded with PennDOT, and we have the new right-of-way established. So we do have the driveway permit as well, which confirms that we've met PennDOT out at the site. They've looked at the site distances and the width of the driveway and the slopes and everything was satisfactory, and the permit was issued.
Okay. As part of this, if this home were to be built here, there would need to be an assurance that there would not be any additional stormwater runoff that would negatively affect any of the surrounding properties. Is that correct?
Yes.
Okay. And you're intending to meet the Lower Makefield Township ordinance requirements as part of that stormwater design. Is that right?
Yes, and Exhibit A8 shows how the drainage patterns are in the area.
Okay. And you will also, if necessary, procure an E&S permit from the County Conservation District as well?
Yes, correct.
Okay. Do you believe, Vince, based on your experience and your testimony as an engineer, that there's anything that can be reasonably developed on this property without receiving relief for a front or rear yard setback?
No, in fact, when you look at the special setback that exists, it's 100 feet, and you look at the rear yard setbacks being 35 or 40 feet, that would encompass the entire project. So nothing can be built here without setback variances,
Okay.
which would be the same situation as all the other properties that front on HEACOCK.
And do you believe that this is the, therefore, reasonable relief that's necessary to develop the property in a residential manner?
Yes, absolutely.
And then my last question, Mr. Fioravanti, is I made a statement that was indicating that the rear of the property is 25 feet, but there is a large side yard because of the elongated nature of this property. Do you concur or have an opinion as to whether the orientation of this site would allow reasonable usage for a future home buyer to enjoy this lot if the home is built?
Yes, if you look how we have everything laid out, and that would be, I guess, Exhibit A2, that's the rendered plan, if we can have that one up there. Yeah, that's good.
Do this one or the green one?
I guess the green one.
Sure.
If you look at the orientation of the lot and the driveway, essentially we're trying to work with the shape of the property that we're giving. The entrance would be at the one side. It's a wide property, of course, 200 feet wide. We have cars parking here for 6 cars, so you could have visitors. There's nowhere to park on the highway, but you could have visitors. They can all make K-turns and they can leave. The rear yard is essentially going to be occupied by a swale and trees that will provide an evergreen buffer, which we discussed. And when you look at the property, at the architectural rendering, which we can get to, there's a front where you can walk into the front. There's a garage and a porch, but also a front that faces HEACOCK Road, so it looks nice when you drive by. And the other side yard could really function as a rear yard in terms of use by the owner. So if the owner were to use this, would be the rear yard essentially, even though this is really the rear yard, that we envision this as being used as the rear yard if someone wants to sit and have a hot dog or something. So the shape of the property does allow it to be used, I think, in a good residential manner. I think it'll look nice if you look down at the, there's a couple of sheets back. Let's go with maybe to A4 for a minute. That's two more of the similar lots. Okay, this is just, as I'm passing it, I don't know that we got to discuss this, but you can see the lots here. Here's the, I'm pointing with a pointer. 1, 2, 3, 4. There's 4 dwellings right here, which you can see in the aerial. That essentially are the same distance from 4 buildings that are the same distance from the road as are proposed. And I think the next one would be the architectural in the next exhibit.
Is that A5?
Yes.
That was the fourth one. Yeah.
Again, we talked about the, when you come from the driveway, you have an entrance and you'll have a garage, and from the HEACOCK Road, you'll have an entrance, so it'll look like a front. And then you also have that other side yard that could function as a rear. So we think it could be a nice addition to the community. We think it's in harmony with the development and actually matches the distance that the other HEACOCK Road parcels have been developed with.
That's all I have for Mr. Fioravani.
Excuse me.
Those pictures aren't like actual renderings. That's like a existing home essentially, right? Like, because wouldn't the garage encompass the entire side lot? Like where your driveway ends would terminate at a 2-car garage, or am I misinterpreting that?
We're envisioning, but we're not specifying the complete architecture. The driveway's permitted, but we're envisioning a 1-car garage and a porch to enter. But that may change as they develop the house plan.
Okay.
All right, board. I'm sure people have lots of questions.
I want to start with the trees. It looks from the pictures that the lot's covered with trees. Is that accurate?
Oh, you can answer
Okay.
that.
We did look at the trees as well, and we did have an arborist come out to look at the trees to see, if they were worth preserving or what the condition, nature of them are. And we did get a letter from Shire Tree Expert LLC, which I guess we could submit as evidence if we need to. This says that physical review of the site identified vegetation typical of fallow land undergoing natural succession. The growth consisted primarily of small deciduous trees and saplings, crabapple, shrubs, thickets characteristic of abandoned fields, herbaceous ground cover of unmaintained parcels. No mature tree canopy of long-established woodlands were observed. In conclusion, this land parcel represents an abandoned agricultural field in natural reversion with no vegetation older than 35 years. So again, he's essentially saying it's an abandoned agricultural parcel in succession, that it wouldn't be characterized as a woodlands, just an abandoned parcel for 35 years.
Following that line of question, I don't know if this is for Dan? Is this parcel covered by any of our ordinances for tree removal and percentages and things like that?
I think that would just be for a subdivision, so I don't think it would be
Okay.
applicable for a single-family home.
You want to mark that A13?
The letter?
Yeah, and just give me some description of who authored it and the date.
Which we handed in.
Yeah, I can submit this up, Adam, if that helps.
Mr. Fioravani, one question. You had mentioned 110 feet, I believe, to the closest neighbor.
Yes.
Would it be right in saying, is that the property at
It's the neighbor to the rear.
rear 1602 Pen Oak Circle, or?
Well, directly behind the rear yard of the proposed lot.
So the property that is on HEACOCK or on Heritage Oak Drive?
Heritage Oak.
Okay. And have you Has anybody as part of this plan communicated with the owners of that property?
I'm sorry, I didn't understand your question.
Have you guys communicated at all with the owners of that property? I think it's the Links.
I haven't personally.
Okay.
Did Mr. McGinnis, Mr. McCafferty, did you just hear the question from James? Did anybody from the applicant side reach out to the homeowner directly behind?
No, I haven't spoke with any of the neighbors. Not being part of the first application, I didn't have any names, contact information, things of that nature.
Okay. Question. So part of your presentation tonight is the side yard polar opposite of the driveway, so the other side. You're talking about how that could be used as a rear yard. Would that be something that you would be comfortable deed restricting where the actual backyard behind the house, no improvements could be built back there?
Yes, I'd be comfortable with that.
Okay. And then, yeah, I saw this. Mr. Fioravanti, you said you met with PennDOT out at the property, and you were talking about discussing a minimum frontage per PennDOT, and that everybody, anyway, your plan has it at 18 and a half feet back, right? So was that the de minimis, or would PennDOT allow the house to actually creep a little closer to the road if it would bring it off the rear property line?
We didn't discuss the distance from the road as much as the width of the driveway for vehicle maneuvers. But they did want the ultimate right-of-way. We agreed that it would be 5 feet behind the curb, which put it at 35 feet. And then from there, we gave 25 feet and 18, just to kind of match everyone else that was on HEACOCK Road. I don't know that PennDOT would really have an issue if within our building envelope we went closer to the right-of-way. They only really have jurisdiction now in the right-of-way itself. So I think we would be fine if we moved it closer to the PennDOT right-of-way. I don't think PennDOT would have an issue with it.
Well, and the reason I'm asking is I see a lot of people in here for public comment, and I remember last time there was some public comment. So, and I remember last time the sticking point was the back of the house being 10 foot off the property line. So I'm just wondering if that might be a solution to help ease concerns. By the way, Ms. Carlton, you can jump in any time with questions, comments.
Thank you. I was going to let all the board ask their questions, and then
They seem quiet tonight.
you do.
Board?
So the three properties, Mr. Fioravanti, did you do a variance search on those three properties to see what kind of variances they may have had?
No, I was just looking at how we match up in terms of distance to HEACOCK Road. So I didn't go into their zoning history.
So, Dan, is that anything that you might know of,
Not off the top of my head, unfortunately.
I mean, my experience, Bob, with that is they appear to be older farmhouse-style properties that most likely predate not just this current zoning ordinance, but probably prior ordinances before the existing current ordinance in our township. Basically, they're most likely grandfathered.
grandfathered in?
Yeah,
So.
most likely.
They probably wouldn't have passed any of the variances if they were built today.
In other words, they would require variance if they were built today. Yes, they would definitely
because
require
This
variance.
lot's been the same since the 30s, and I think we started doing building permits in 1939. So,
Thank you.
yeah.
I'm interested to hear what the neighbors say, but I do want to point out that the area is zoned residential, and it does look like it's an attempt to balance all the comments and resolve all the issues, and the drainage plan makes sense, and the answer with the tree coverage helps. We did discuss tree coverage on a single property development before, so it is a concern.
And here I thought you were just going to be quiet all night. Ms. Carlin, I think, yeah, why don't you weigh in?
Thank you. I did just take a quick look at the Shire's tree report. Having not inspected the property physically, I do take exception to it. It does appear that it is a woodland as considered, or by definition under our ordinance, but that's something that will have to be decided. I think the tree report, in quotations, is a little lacking, quite honestly. Mr. Fioravante, what is the distance, and I know you've stated this, I just want to double check, the distance from the proposed dwelling to the edge of road?
26 feet.
26 feet, and that is the right-of-way, the edge of?
No, that's the actual paving. So we're 18 and a half feet to the right-of-way, but then that's 5 feet more to get to the street.
Okay. And what was just, I know you explained what was dedicated to PennDOT over the past couple of months, I'm guessing
Yes,
it was?
35 feet from the center was dedicated to PennDOT as permanent right-of-way,
Okay.
where before the ultimate right-of-way was 60 feet wide from the center.
Okay. Do you have any idea what the likelihood of HEACOCK being expanded?
We discussed it with PennDOT, and they said they had no plans now or in the future to do anything with HEACOCK Road, and that's why they didn't actually want the extra land. It was a liability for them without a need.
And what is the current configuration of HEACOCK right now? Is it a,
Well, the paving is 60 foot wide, so it's 30 foot from the center. So we gave them 35 foot right-of-way, so it's beyond the curbing. But it was 60 feet from the center, and they didn't want that extra 25 feet.
okay. I know you explained the orientation of the house and I don't know if you did describe the length, the proposed length and width of the house?
I did not. We probably have the dimensions here, 28 by 56.
Is there any way to reduce the width or the width of the house to possibly, to lengthen it or elongate it, to increase the rear yard and possibly even the front yard?
I guess it's always possible to start to change the dimensions of the dwelling. I think that 25 feet that we have in the rear, though, is plenty. You know, you start to have where you start to make changes to, let's say, I'm going to exaggerate, you make the house 10 feet wide and 50 foot, 10 by 50. It makes the rear yard nice, but now the house is less desirable. So we're trying to balance everything. We didn't want to go too close to the road, so we went 18 and a half feet because you don't want to be 5 feet from the street. With 25 feet in the rear, we felt that's plenty to do adequate buffering, and it left us with a 28-foot wide dwelling, which we thought is still desirable. So you kind of balance in three different things. We could always make the house less deep, but then it's less desirable. We could move it more forward. It's just kind of a balancing act, and that's where we came up with what we do have.
I'm sure it comes down to economics as well as for the sale
It has to
of
be
the
a
property.
desirable dwelling.
And I think you did testify that you would be agreeable to a deed restriction as to further expansion of the rear. Right now, are there any decks or patios proposed for the rear of the house?
No, we're talking about the side yard where, no, in the rear, we have nothing but swales and evergreens, and I think we would be comfortable agreeing to that.
So no decks, patios, no real outdoor
Not in the
living at all?
25 feet rear yard where we have the buffering and the swales for stormwater. That's what that would be used for.
Okay. So again, no outdoor living, so to speak, no patio, no deck,
Maybe on that side yard.
side yard?
Yeah.
Okay.
Right. Again, the side yard would functionally become the backyard with this project. So a future homeowner may want to put a patio or deck on that side yard. That's going to be the large usable space. But again, the rear yard with the 25 feet, it's essentially going to be used up with screening and swales.
Understood. Okay. Just for the record, the township is concerned with just the reduction in the front yard and the side yard. It's no exaggeration that it's a substantial or huge variance request from, 100-foot front yard setback to a requested 18-foot 18.5-foot yard setback, and a 25-yard rear yard setback when 50 feet is required. And again, I do take some exception to the tree report, not having had the opportunity to look at it prior to today, to analyze it, but it just from aerials and what that area looks like from a drive-by, it certainly looks like it may be considered a woodland under our current ordinance.
So if I can just briefly, for the record and for our purposes, we aren't asking for a woodlands variance. So the tree report at this point, we can admit it, we did, it's not germane. The township is going to have to do an analysis if a variance is granted as to whether it's compliant with the ordinance section with respect to woodlands. We're not asking for a woodlands variance, so there's no obligation to circulate a tree report. We're of the position that we're compliant. The township is going to obviously have to agree or disagree with that. And if they don't agree with that, we would need to procure further relief with respect to woodlands.
Correct, and I guess with due respect, I guess that's one of the concerns, that is not a requested variance, whereas I believe that the township believes that it may be or should have been a requested variance. So that is something that I think has to be reviewed.
Based off of what numbers? What percent?
The woodlands?
Yeah.
Based on the current ordinance, it states that if it's over a quarter of an acre, with, I just had it before me. No. It's just with reference to ordinance.
And if you have it at the,
51.
if you have it on the tip of your tongue, please share it.
Yes, in front of him.
I wrote the ordinance. So just for definition purposes, a woodland in Lower Makefield Township, there's two means of defining a woodland. One, it's a grove of 10 trees or more with a DBH, diameter breast height, so about 4.5 feet of 10 inches or more. That's one version of a woodland. The second version is a stand of trees a quarter acre or greater with a minimum DBH, typical DBH of 6 inches or greater. So that's why we're looking at a woodland here, because this has been this has been forested since at least 1995 based on historic aerials. So that's why we're questioning that.
All right, that introduces something new into this matter. So clearly, requesting the woodlands variance was not something that was submitted. It would require a new application and new advertising. But where do we stand with this? Help me out, solicitor.
I mean, that's a determination that has to be, that as far as variances that are needed, that's something generally that is done. The applicant submits an application. Sometimes they know the sections that they need variances from. Sometimes that's Dan or Jim or both working with them on what variances are needed. But once those determinations are made, then it comes to,
Right.
they advertise it and it comes to us.
Right. So,
But that's a determination
For
generally
the-
made by Dan and Jim in that office as to whether that variance is needed or not.
so for the matter in front of us tonight, we should probably table that part of the discussion, make a decision on the variances in front of us, and then that issue could be reviewed by our township engineers down the road. Does that make sense? Is that something that you would advise? Do you understand what I'm asking?
Yeah, I mean,
That was kind of how I interpreted it too, Jim. Essentially, like, comment on this we're looking at now, but with, the specification that we have to address whether or not they need a woodland variance.
We're not making they didn't ask for it, so we're not voting on it.
Yeah, it's not in front of us,
Yeah.
and we're not even sure it would
If it's
be
a-
required.
If I could pull out another worm from that can? Looking at the picture, and I realize this is just conceptual, okay? Based on the concept you have here, do you have any idea what percentage of impervious surface you're going to hit with this building.
Right there. Right there.
It's 28, but let's confirm that. Yeah, 28.28, I believe.
Okay.
Right there, and that's below the code, like I said, it's below.
Got it.
the
All right.
code requirement, so.
Eyes are getting old.
Vince, the lot itself is 200 by what, 70?
71.5.
71 and a half, okay.
So we have to figure out, again, I think it makes sense to render a decision on the variances in front of us tonight and then see how the forestry ordinance shakes out after the fact. It could be a moot point, or it may need to be addressed depending on which way, what the decision.
It could be determined, I guess, if it were granted, if they were to file a building permit, and then if they were to file a building permit, we could see if they would need a variance for the woodlands.
That's what I'm suggesting.
Okay, no, that's what I'm talking, how we would do that administratively.
Yeah, administratively, that seems to make sense.
Okay, yeah.
Yeah. Ms. Carlton, does that make sense to you in the township?
Yes, with the understanding that the applicant would be providing the woodland assessment, and we would just be reviewing the same. But yeah, that would be my suggestion, that you could go forward with the variances in front of you this evening.
And then administratively, when they apply, if it is passed or approved, when they applied for permits, at that point, our engineers would make the decision on whether they would need a variance or not. That's my understanding. Is that how you repped it, Dan?
Yeah, that's how to be honest, all variances, like we kind of say file the building permit, and then from there, we can kind of tell you all the relief you need. So I think that makes the most sense if it were to be granted.
So generally, if we were asking for woodlands relief, typically what happens behind the scenes is when there's a property that has trees on it, there's a consultant that does an analysis and says we think a woodlands variance is necessary or woodlands variance is not necessary. And if the determination is that they believe it's necessary, then we could have an arborist that submits a report and says we need a variance of X percentage based upon our analysis of the caliper inch trees that we're removing, et cetera, and then that would be submitted as part of the application packet. We didn't submit that as part of the application packet because the consultant who we dealt with said we don't believe under the ordinance standards that this meets the definition. Now, we could be wrong about that. We would, I am assuming if variance is granted, would then have to submit a report to the township that is different than that letter, and then there would be an analysis done, and the township would either agree with that or disagree with that. If they agreed with the analysis, then we wouldn't need additional zoning relief. If they disagree with the analysis, then there would have to be the analysis that's calculated as to what the percentage is and to come back. That would be my suggestion.
Yeah, I think we're all in agreement.
Yeah, that makes sense, because there'll be multiple eyes on the permit too. It'll be me, myself, Jim, building reviewers. There'll be multiple people to review it.
All right. Kick that can down the road. Any additional questions from the board?
Just to go back over it again. So the setbacks as currently defined in the code without variances would mean that nothing can be constructed on this property.
Correct.
Thank you.
All right, at this time, before I call for public comment, I just want to go over what I usually go over when we have more than a handful of people in the room. So please try to come up, be concise, try not to repeat exactly what people who came before you said. Ideally, you're getting up and but first of all, you're going to be sworn in, and if you live within 200 feet, how far away to be a party to the matter?
Notice is 200.
Okay, so if you receive notice and you want to be a party to this matter, you can indicate that when you get sworn in. Got a microphone check, testing.
Yeah, we got to turn it on. Is it on? We're good.
Beautiful. Anyway, so you'll be sworn in, you'll give your address, and again, please be civil, please be concise, and try to be less than 3 minutes, please. All right.
And I just want to add a couple things. If you do request party status, just give us an opportunity to work through that. If you are someone that did receive notice in the mail, generally, those people are automatically given notice. If you are outside of that and still requesting party status, you're going to need to give us some basis for that. But anyone that is granted party status can also ask questions of the applicants if there is additional information that you need. Otherwise, if you're not and just making comment, you can make comment and then move on.
And Adam, will you just take 30 seconds and explain the significance of party status, please?
Oh, I'm sorry. I forgot you didn't do that. Party status gives you, again, the ability to ask questions. You call it cross-examination of the applicant or their witnesses. It also gives you the ability to appeal the matter if it was, if the board ruled in a way which was not favorable to your position. You don't have to request it, but it does provide certain legal rights and appellate rights.
All right. First person, please come forward.
State and spell your full name, please.
Sure. My name is Joshua Link, L-I-N-K.
You solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
First, I'd like to thank the members of the board for the time and the opportunity to speak here tonight, understanding the chair's direction to be as concise as possible. I will try to do that. This is also a matter of extreme importance to my wife and myself and my family, but I will keep the chair's direction in mind.
As long as you're moving it forward and not repeating yourself, you can go over 3 minutes.
That won't be a problem, sir. As you just heard, my name is Josh Link. Together with my wife, Leanna, we own the home at 1602 Penn Oak Circle.
So are you requesting party status?
I'm sorry, we are requesting party status. We do oppose the appeal. The parcel at issue, as you've heard here tonight, is directly behind our property. That is to say that our property is directly adjacent to and runs the entire length of the east side of the parcel that has been described here tonight as 0 HEACOCK Road. My wife and I bought our house in February of last year. It's the first home we've ever owned. Needless to say, we bought the house during a time of record high housing prices and near recent record high mortgage rates. It is by far the largest purchase and investment we've ever made. We bought the house at that time to have a place to raise our 2 sons, Nathan, who's 2.5 years old, and Connor, who was born less than 2 weeks after we moved into the house and is now 10 months. One of the main reasons we bought this house is because of the space, quiet, and sense of privacy that our property and the Heritage Oaks community in which it is located provide. The houses in our community are not right on top of each other. They're spread out. They have large backyards and lots of open space. Our house is on a cul-de-sac. It doesn't face any other houses. Our windows do not look directly into our neighbors. Our backyard is private, or at least as private as it gets right in this part of Bucks County. We can sit on our back deck without feeling like we were being watched. My kids can play in the yard. We can have get-togethers without worrying about the noise affecting our neighbors, and conversely, they can do the same with their properties without bothering us. The quiet space and sense of privacy was a huge reason why we fell in love with and bought our home. It is also, I have to believe, a main reason that this community is attractive to people and a desirable place to live. And it is these characteristics of this community that will be affected by JMAC's proposal here this evening, and that the R3M classification, it would seem, is designed to protect. I would just want to highlight, I think there was some comment earlier, but I don't know that we've heard the word R3M said here tonight at all during JMAC's presentation. I think that's with reason, and I'll get to that in a minute. But what JMAC is requesting here isn't so much a variance as it is asking the board to completely disregard fundamental zoning requirements that are applicable to that parcel and every other parcel in the area. The minimum rear setback requirement under R3M is 50 feet. That's the minimum requirement. The majority of homes in Heritage Oaks and the Ashley Estates developments, which is the community in the immediate area, are much further from the rear property line than the minimum 50 feet. But what JMAC is asking here isn't even close to the minimum. They're asking for a 25-foot variance, which is extreme. Okay, it is only half of the minimum requirement. And you heard some discussion about how this is perhaps acceptable because the last time not JMAC, but the last time a variance request for this parcel was before the board, the setback was 10 feet, and now it's 25 feet, which is obviously a difference of 15 feet, right? That is not a meaningful distance. 15 feet is a free throw. That is literally the distance between a basketball hoop and the free throw line. We're not talking about a couple of feet. If we were talking about a couple of feet, my wife and I would not be here opposing this appeal. The reality is, if JMAC is allowed to do what it is asking to do, we will have a two-story house. And let's be realistic, we will have at least a two-story house because under R3M zoning, that house will be zoned for up to 35 feet in height. But we will have that house towering over our backyard. We will be the only property in the entire community with another house looming over its property line. This house will be located directly across from the back of my home. The windows will directly face into the windows of our two rear bedrooms and our master bathroom. The sense of privacy in our backyard that we currently enjoy and which we value so much will be shattered. And rather than peace and relative quiet, we will have to contend with noise. Noise from a house and neighbors that are located very, very close to our property line. Noise from a construction project that will undoubtedly take months to complete and which will be occurring directly behind the bedroom that my 10-month-old son sleeps in. During the presentation tonight from JMAC, there seemed to have been some suggestion that the house they propose to build is consistent with the character of the surrounding community. And in doing that, they focused the board's attention on 2 or 3 different houses, right? The farmhouse parcel to the south that has 2 residences on it, and the parcel to the north, both of which have driveway access to HEACOCK. And they suggested that those properties are comparable and representative of the surrounding community. That is simply incorrect. Again, the community in the area is the 100-odd homes in the Heritage Oaks and Ashley Estate development. Those houses, I believe, are typically 3,200 or 3,300 square feet if you're counting finished basements without exterior ingress and egress access, right? The vast majority are not only compliant with all setback requirements under R3M, front, side, rear, right? But considerably they comply by far greater than the minimum setback requirements under the zoning classification. The houses in the development located across Stony Hill Road from Ashley Estates appear to be even larger and even more spread out. And directly to the west of HEACOCK Road, there is another planned community that appears to consist mostly of carriage homes and townhouses. Worse still, the 1 or 2 houses that JMAC is identifying as representative of the community are not even appropriate comparables to the development it proposes. Starting with the farmhouse on the south. Public information shows that farmhouse was built in 1892. Okay, it's the original farmhouse and the remaining structures on that parcel from the farm, the land on which Ashley Estates and Heritage Oaks were built, right? And while it does have driveway access to HEACOCK Road, and the residences are not set back that far from HEACOCK, it's prior non-conforming development. It is development from literally 2 centuries ago. It's been there since before everything else in the area. It's probably been there before HEACOCK Road even existed. I think certainly before HEACOCK Road existed in the form in which it does now. And in any event, the rear setback for those 2 residences on the farmhouse parcel are way more than compliant with the minimum requirements under R3M. I think it's several times over. It's about 150 feet. As for the property on HEACOCK located directly to the north of the parcel, again, well, first off, that is a single-story ranch house. Public records or public information again shows that house was built in 1956. The driveway for this parcel does access HEACOCK, but again, that is where any similarity to the proposed development ends. It is, by all appearances, compliant with the front setback requirements under R3M, and it has a rear setback of several hundred feet at least. You cannot even see the parcel to the rear of that property, where the ranch-style property, where that parcel ends and the next one begins. Excuse me. I think there was some suggestion during JMAC's presentation that it should receive this variance because JMAC didn't cause the hardship requiring the variance because it did not alter the parcel in such a way that the variance is necessary. There was no representation tonight about when JMAC acquired the parcel. As the chair mentioned, at the beginning of these proceedings, there was a prior hearing during June of 2023. At that time, the parcel was owned by ADR Investments, LLC. So JMAC has obviously acquired this parcel at some time within the last 1 or 2 years, right? Again, there was no representation about how much JMAC paid to acquire this parcel. Again, during the public hearing a year and a half ago, it was discussed that the previous owner purchased the property for $2,400. Excuse me. In any event, any suggestion, I think, that JMAC has a hardship under the circumstances here is preposterous. In June of '23, the board denied the previous request to develop this property unanimously. Given the public nature of those proceedings, JMAC had to have known that the board had already confirmed that this parcel is entirely unsuitable to residential development in conformance with applicable zoning requirements. I think it's also, I do not think it's in dispute here tonight that certainly when JMAC acquired the property and when ADR acquired the property previously in 2018, that everything was situated just as it is now, right? The parcel at issue was exactly the same location, but same size and dimensions. HEACOCK Road, the parcels to the north, the south, my property, the entire community around it, all just as they were, all just as they are now, and all zoned for R3M. Obviously, the property we're talking about is in Lower Makefield Township, right? It has a Yardley address. It's in the Pennsbury School District. The only possible reason that JMAC and ADR before it would be able to acquire this parcel for a proverbial song and a dance, right, is because it is plainly, obviously, and indisputably unsuitable for residential development under the then and current zoning classifications. The only thing unique or peculiar about the parcel at issue is it is plainly unsuitable for development under the conditions generally created by the township zoning ordinances. JMAC knew all of this when it bought the property, and they did it anyway. Excuse me, I'm trying to streamline things here based on the chairs.
You're doing a good job.
Well, thank you. There was some discussion earlier about attempts to contact the neighbors. I can tell you my wife and I have lived in our home for almost a year, right? During this entire time, neither Mr. McGinnis, neither anyone at JMAC or on behalf of JMAC has ever reached out to us to discuss the proposal, the variances they're seeking, what our concerns might be, and if and how they might be addressed. Instead, we only found out about these plans a week ago, and then only when we received the notice of hearing from the township. Just briefly, I would like to address the precedent I think the board risks setting if it grants the variance here tonight. The parcel we are discussing is a strip of land that buffers a large planned residential development and what I'll call an arterial road. I think this is not an uncommon feature of the many communities similar to Heritage Oak throughout Yardley and Lower Makefield Township, and that are representative of the homes in the area. If ADR gets its way here tonight, if JMAC gets its way here tonight, That will undoubtedly encourage other developers to buy small buffer properties that are plainly unsuitable for development, and then request extreme variances to develop them. And then at that point, it won't just be this community that is affected, it will be the entire township that will be affected. Section 200-5 of the Township Zoning Ordinance provides that in interpreting and applying the provisions of this chapter, they shall be held to be the minimum requirements for the promotion of public health, safety, comfort, convenience, and general welfare. I think that bears repeating. These are the minimum requirements necessary to promote public health, safety, comfort, convenience, and general welfare. JMAC is not asking the board for a small departure from the minimum requirements. What they are requesting is extreme. It's so extreme that it will lead to a house towering over my backyard. If granted, the development that they are proposing, again, is not at all consistent with any development that I'm aware of that has taken place in this community in the last many decades. And from a personal standpoint, the variance JMAC is requesting and its proposed development will come at great cost to my family, our ability, our right to the quiet use and enjoyment of our home, all of which were present and protected by the conditions that existed when we bought our home, and which have always existed in this community and will be forever and negatively affected. As one member of this board said during the June 2023 hearing, not every parcel can or should have a house on it. When the board unanimously denied the last variance request, I believe that the board members were promoting the interests of the surrounding community and the neighboring homeowners. I'm hoping, I'm pleading that the board once again place the interests of the homeowners who already live in the area and the community before those of a development company that is seeking only to turn an extreme profit based on a small speculative investment. Please, the members of the board cannot allow this to happen to my family. Thank you.
Thank you. Well done. Would someone else like to come forward?
State and spell your full name, please.
I'm sorry?
State and spell your full name, please.
Larry Borda, B-O-R-D-A, 508.
One more time and slower.
Larry Borda, B-O-R-D-A.
Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I won't reiterate anything that Josh said. I thought you did a bang-up job. And I don't take issue with anything. In fact, I join in everything that he said. I basically live across the street from him. This issue comes up every few years. Somebody tries to come in here and buy this lot on the cheap and hope that the township will lose the intestinal fortitude to uphold the township ordinances. The township is opposing this at this time. The township has always opposed this for the reasons that Josh pointed out, which is, why are we bending it backwards to accommodate somebody who's coming in? There's no injustice being done here. The people who own this property or have rights to it knew what they were buying into. I don't see why we should try and make any special effort at making an accommodation. The houses that were being referred to as analogous to this are older houses, similar to farmhouses, which you often see very close to the road. And you know why they're there? Because they're grandfathered. This would basically be a stick-on. This would be a sore thumb on HEACOCK Road, similar to that house you see across from the Yardley Country Club, between the country club and the railroad tracks. You have that little house stuck in there. Well, that's what this thing's going to look like. It's going to change the character of the road, and the entrance to my development is immediately adjacent to that particular location. So for those reasons, I'm asking that you deny this, and I ask for interested party status because I think the outcome of this decision will affect the value of my property. It won't affect my property as much as it will Josh, but nevertheless, it will affect my property. I also had one more question. There's a reference to a grinder pump in the southeast corner of the property. Do we know what that's for?
That would be for a sewer system. Dan can testify, or Dan can mention how that
Does
fits
every
in.
house have a grinder pump, or why is that needed here?
I would ask the applicant or the engineer.
A grinder pump is a typical system used when a gravity lateral connection can't be utilized for a sanitary connection. They're commonly used.
So it's something to take the sewage to a higher elevation to meet up with a sewer line?
Yes.
Thank you.
Name's Paul Elrath, Paulelrath.
You solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I'm the owner of the property directly next door, the 536 and 542 Heacock Roads, the two parcels that were constantly talked about as similar properties. Similar to what Josh said, these are old properties. I own both of them. I don't live in any of them. There's tenants that live in both of them. Constant complaints, noise. It's a horrible place to live directly on top of Heacock Road. It's a very busy road. I just think it's awful. There's line of sight pulling out of the property is very difficult to see. The properties just hang over top of Heacock Road and there's nothing really good about the houses. The tenants that live in them constantly complain about the noise. I know to ask for a 18-foot setback when the ordinance is 100 feet I agree, just absolutely absurd. When I purchased the property, I know that the properties, the two houses on my parcels were in the right-of-way. I was made aware of that prior to purchasing the property. I knew if someday they expand Heacock Road, I could be, they could take the houses down or I'd be forced to move them. I'm okay with that. I think it'd be a great thing for the township. I'm a resident of 43 years. I've lived here my whole entire life. It's a great community. I love the zoning, love everything about the town. Someday I could see Heacock Road being expanded. It's pretty much 2 lanes each direction, all the way from Oxford Valley Road and down near the Wawa. And pretty much this would be the last piece. If they ever wanted to expand the road from Oxford Valley Road all the way to 295, this would be the only piece that would stop it. So that's something I see as an important thing to look at. Might not happen in our lifetime, but in the future, we should think of the other people that are going to live in the community after us. There's also a sidewalk that does not connect due to my property, this property we're talking about, and the one neighbor's property that I could see being a really nice thing to someday connect. At some point, my property, when I purchased it, I knew I'd someday probably build some houses, maybe move my houses back, live in them myself possibly. And I was very aware of that, and I think it'd be I'm more than fine to have the proper setbacks on my property. I think it's the right way to do it, and the town has the zoning rules for a reason, and I hope you guys continue to abide by them. So that's it, and I would like to be involved in future conversations about this.
Are you requesting party status?
Yes. Thank you.
State and spell your full name, please.
Hi, Joe Hugler, Huegler.
You solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
And I'd like to request party status. I live in behind the property pole. I got notice from the township.
So I didn't get notice from the township either. My tenants did, so I'd like to make sure that I get notice.
That's typically how that works. We would just send notice to the properties that abut within 200 feet. I mean, if you want, we can send you the.
Yeah, send it to where you send the taxes would be great.
Which is the home, correct?
No, it's a bill of
Okay.
I don't have, so just to be very brief, I don't have anything to add. I embrace everything all my other neighbors said. I just wanted to come up and state my opposition to this proposal and request party status. So thank you.
All right. You win a concise award.
My name is
No, you just get the cup up.
my name is Richard Van Horn. I live at 584 Heacock Road. And again, I
1 second, sir. Spell your last name for me.
VAN, capital HORN.
Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole
do.
truth, and nothing but the truth?
I do. Again, I'm opposed to this. I just wanted to make that on the record. And I want to request party status as well. And that's pretty much it. I would like to point one thing out as far as wildlife goes in that little piece of woods. When I go to work in the morning, I bet you 3 days out of the week, there's deer in that little piece of woods right there. I mean, that might not mean nothing to nobody, but it is a little refuge for them to, you know, that they stand in, they sleep in, you know, and that's it. Thank you.
Thank you. Additional public comment in the room? Is anybody online? No one online. Okay. Well, board, this time we've heard from the public, we've heard from the applicant, we've heard from the township. Why don't we discuss this and see if we can make a motion? Would anybody like to make any points?
Yeah, Jim. Listening to what Josh said, I think there's definitely some points to consider. I can certainly understand feeling like a new construction project will be loud, might even provide, once the construction's done, more access to the traffic on HEACOCK, which is an understandable viewpoint from him. I think hearing from the neighbors on either side of that property, like further kind of hits home there. So one thing that had occurred to me, I'm not saying that this is necessarily a solution, but I believe...
Can you speak closer to the microphone, please?
Sorry. I believe Rich, who just came forward, he actually, his property is a ranch, and I wonder if maybe some type of restriction where allowing for a ranch to be constructed might be worthwhile. You know, it makes it so that it wouldn't be towering over Josh's property. Again, I mean, there are some difficulties here, but I think that's one thing that could be discussed in terms of like allowing for development and maybe, you know, kind of a compromise. So I just wanted to kind of put that out there for discussion as a possibility to consider.
So, Mr. McGinnis, that's an interesting suggestion from James. Has your applicant considered possibly developing something that's not 2 stories? By the way, you can take your time and just, you guys can powwow quietly off microphone.
Do you mind, Mr. Dock, if we take a 90-second recess to discuss that?
How about a 5-minute recess? Everybody can use the restrooms. By the way, I'll remind the board, we are not to be discussing this matter outside of being in adjournment. So, all right, 5-minute recess. If everyone could take their seats, please. We're about to resume.
Yeah, exactly.
Thanks, everybody. All right, Mr. McGinnis, you had asked for that recess?
Yes, thank you. We did discuss that, and we would be willing to agree to that as a condition for this site.
You'd be willing to agree to a ranch-style home?
Yes.
Okay. Okay.
Just to confirm, that would make it wider but not otherwise affect any of the relief that you're requesting, correct?
It would have no impact on the building coverage and impervious, and of course, as Ms. Carlton and Mr. Grenier stated, we still need to confirm the woodlands component of it. But yes, the rest of the dimensional aspects we can conform with. That's correct.
Okay, so you still need the same exact relief?
Correct.
Okay. All right. All right, so let me weigh in. Does everybody in the room just hear that? Two-story loom? It's, hold on. Mr. Elrath, you're entitled to come back up and do public comment, but you have to come to the microphone.
So,
Now, wait till you get there.
Paul Elrath. So the question is, if it was a one-story house, what would the square footage end up being, and would you get rid of the garage? Because obviously you're cutting that. You said the house. What was the square footage of the proposed house?
1550, first floor.
Okay, so you'd be down to, and that's with the garage or without? So with the garage is probably, so you'd be down to like a 1,200.
Vince, you need to use the microphone, please.
About a 12, so it'd be about a 1,100 square foot house, we're thinking?
Well, the footprint would be wider if it was a rancher.
Okay, would that affect the pervious?
Well, it would go up, but we would stay within the compliant ratios.
What is the compliant ratio?
35%.
Yep.
Yeah, that's what we just discussed earlier, that they would need no additional relief other than when a building application was made, they would need to, at that point, the township would determine if they needed to revisit the woodlands ordinance. But again, that could be pushed down the road, and if that was the case, then they would have to come back in front of this board. If it's determined they need a woodlands variance, they would have to come back in front of this board. They would get an arborist report, not what they presented tonight. Make sense?
Thank you.
Thank you. Sure, Mr. Borda, come up.
So I'm a little confused on the 18.5 feet. Does that take us from front of building to edge of right-of-way?
Yes.
And as you face this proposed house on the left in front of the senior home, and on the right, beginning in our development, we have sidewalks running parallel to HEACOCK. This particular span does not. So when a sidewalk goes in there, which is logical at some point in time, that distance on the front yard would drop to about 14 feet?
If you're talking from the edge of the sidewalk, I
Yeah.
couldn't tell you. First of all, that's super speculative.
Yeah.
Right? And, I mean,
I'm just trying to get clarity on what this thing looks like when and if a sidewalk.
but that
goes
would
in
be, it would still be their land, right? Mr. Fioravani could speak more intelligently on that.
You'd have a front yard about the depth of a car, basically, at that point.
You should probably direct this to the applicant and the applicant's
Am I wrong?
expert.
If the sidewalk were put in within the right-of-way, then it wouldn't affect the front yard at all. If it was put in an easement or in the front yard, then the front yard would still be the same dimensions. There would just be a sidewalk that went through it, maybe a foot from the right-of-way.
Right, my only point is your green space would be even less.
Oh, it would go down if a sidewalk was put in, yes.
All right, thank you.
All right, so I'm just gonna start off. So again, Pete brought up something earlier, and which was we have a residential district with a residential lot that to do it by right, nothing could be developed there. And then Mr. Link, I thought it was on. Mr. Link came forward and made some excellent points about the decision we made that was made 2 years ago, over 2 years ago, I guess. So there's been a lot of good discussion going back and forth. But when I hear an applicant come in front of us, they took the time to go to PennDOT to get PennDOT to take the right-of-way down, and they try to improve the situation, right down to one of our board members, James Brand, asked the applicant, are you willing to do a ranch? Because, by the way, that's a lot of what I heard. Two-story home, hanging over my property, going to be an eyesore, going to be looking window to window, a lot of that stuff. By the way, reasonable. I think this is a really nice compromise. That's my opinion. Now, I know a lot of people, they don't like any development adjacent to their property. And I get that, yeah, there's going to be a building site for 3 to 6 months, maybe longer. That's all over the country. People have houses built next to them. I'm just letting you know, board, in my opinion, I think this is pretty reasonable. Anybody else have anything to add to that?
So my concern is, how do we enforce the restriction? Style house with down the line, somebody else's property.
It's one of the conditions that we'd attach to the variance. We do those a lot. So in this case, we'd say the height condition to 15 feet or something similar to that, which would restrict it to 1 story, but give them the ability to.
But to his point, though, like, would it need to be a deed restriction, though? Because say 10 years from now, if someone were to file a building permit and they weren't familiar with them getting a variance 10 years ago, they would have no idea, realistically.
We would record it against the property.
Okay,
It would be a
yeah.
public record.
Okay, yeah.
It would have to be of record.
Okay, I'm just thinking, as someone who does zoning permits, I'm just thinking from that,
Just in
from that
the-
standpoint. yeah.
It's made a condition, and then included in that condition is that it's recorded.
Okay, perfect, that makes sense.
I'd like to hear if any more of the neighbors have any more concerns now that it's being reduced in height.
Can I weigh in real quick? One more question, just because I feel like it might add to what some of the neighbors might say. Josh had mentioned about the hardship and the transfer of ownership, and I guess my question would just be what the applicant knew with respect to the existing hardship when they did acquire the property.
I didn't hear that, I'm sorry.
James, did you just ask, was the applicant aware of the hardship when he purchased the property? Was that your question?
Yeah, sorry. Exactly, and the former meeting that had happened. I was trying to look at the public record for when the transfer happened, and I couldn't really see.
Right now, he's an equitable owner.
Right. Part of the introduction, Mr. McCafferty is an equitable owner, so he's under agreement to purchase the property. He doesn't own the property currently.
Gotcha.
And yes, I mean, most of the time when there's an application that's predicated on relief forward before a board, that's discussed, and then that necessitates the application to the ZHB, and then there would be a closing that occurs afterwards, but the property owner has vested Mr. McCafferty with all the rights to agree to the conditions that we're discussing this evening, because he would be then the owner and it would be recorded against the land subsequently. Mr. McCafferty was aware of the prior zoning decision, and that is why there was substantial effort that was undertaken over the last year to improve the status quo on the property, to increase the setbacks and mitigate the potential impact to the property owners.
Gotcha.
Where last we left off, Mr. Schwartz, fellow board member, inquired if any of the public comment in the room would like to come forward in light of what's been proposed.
Paul Elrath. So the question, I guess, would be if down the road here, maybe not in any of our lifetime, but in, whatever, 50, 70, 100 years, they decide to expand HEACOCK Road,
what would happen to this property if it had to get condemned or knocked down, or how would that work? It'd be a foolish move for Lower Makefield
I mean,
to approve this.
they would probably take it through condemnation and it would probably be a whole, probably if the improvement itself, my experience is if the improvement itself was in the taking, it would be a total, not a partial taking, it would be a full taking of the property, and it would have to go through eminent domain.
Lower Makefield would have to pay,
Now, that would, if it's a
No,
PennDOT
that would be
road.
PennDOT.
So
they would have to pay, though, the current market value for the property.
correct, fair market value for.
Yeah, good luck with that when you're dealing with PennDOT, but yeah.
No, but they,
It's worth maybe nothing or $2,400, so it'd be doing a disservice to future.
You're worried about PennDOT?
Yeah.
Look at you.
Yeah, that's.
You're a mensch.
And, I mean, once again, I do agree. I think that sidewalk has to go in or will go in at some point, and just to reiterate, at some point, my property, which the two properties that are very close to the road that we were talking about, those properties, those two houses will not be there forever. I can assure you that. You know, the plan is at some point for us to build, you know, houses on that property with proper setbacks. So that will no longer be affected, and I hope that.
Just lean in a little bit.
I hope that we could, you know, put a sidewalk in to connect the sidewalk to get people from Heritage Oaks safely towards McCaffrey's. That's it.
Thank you.
I'm just going to note one thing, since the current plan is to kick the can down the road on Woodlands. Under the current proposal, if you do build a rancher and it's a larger footprint, it will have a bigger impact on any potential woodlands and how much can or cannot be preserved. So with that in mind, take that into consideration, because if that does come up before us, you'll have to take into account the fact that the proposal and compromise was to make it a larger footprint, which provides less space for woodlands. So if that does come up down the line, please be aware of it now.
Is that a warning for us, or is that a warning for the developer?
It's for everyone that it should be known that will, if it is determined that they need a woodlands variance, this will affect that directly.
Joe Hugler again. I'm Joe Hugler, Huegler. So I'm not necessarily moved by the reduction in height to a one-story building. It's still extreme variances to the setbacks, and you know, if we let that, say, in the future, it looks like a very bad decision. If that road's improved, and you say, well, that's PennDOT's problem. Well, it's still my problem. It's tax dollars, and I would like us to make good decisions all around, not just in our own fiefdoms. So I still am unmoved at this point. So thank you.
Thank you.
I do want to say first, I do appreciate the board and everyone's efforts to reach a compromise here. I do. As Joe just mentioned, though, this is still an extreme variance that's being sought in connection with the rear setback. And while the reduction in height does alleviate some concerns I've had, it doesn't alleviate all of them. But I also have a question about the deed restriction, the prospective deed restriction that's being discussed here. What I'm understanding is there would be a recorded restriction on the buildable height or the allowed height of any structure that is on that property, right, which would then run with the land to be binding upon subsequent homeowners. And I'm hoping for some clarity as to the continuing legal effect of that restriction, because land usage restrictions continuing in, you know, forever and always, right, can be problematic. Do we have any insight into the what I'll call the temporal limitations upon that restriction, and how every potential subsequent owner of that land will be required to comply with that restriction?
Solicitor?
Sure. So there's a lot of times that you can have deed restrictions for a whole slew of things, whether it's not developing a certain part of a property, in this case, limiting the height. So any subsequent owner purchases that home subject to that recorded restriction. And in this case, whatever that height is determined, if a variance is passed, you get that property with those restrictions on it. So and because it's recorded, before you buy that home and you do your title search and all of that, all of those things show up. And so it's known now and it's known for the future, and it's not, just a condition of this approval where maybe someone doesn't see it. It's actually in the property records themselves, and that goes forward.
Okay, thank you.
Can I add, though, that deed restrictions are a record, as the solicitor just stated, but it does take someone to enforce those deed restrictions. So deed restrictions can be a record, 100 years from now. 100 years from now, if you're lucky enough to be here, you may want to choose to enforce that deed restriction. Your subsequent owner may not. So it does take someone to enforce those deed restrictions as well.
And I appreciate that explanation, because that is a concern I have, that when someone violates that use restriction, then I am responsible for enforcing it and potentially in litigation or whatever posture I will be in. That is expensive, that is time-consuming, and is not anything anyone ever wants to find themselves in if they can avoid it, certainly.
That is correct. I mean, you have the benefit of it being a deed restriction of record for all the world to see, so to speak. But again, it does take someone to enforce that. So if someone violates it.
But an application would have to be submitted to the township for a building permit that would then have to be approved. And I'm assuming that if this is granted, that would go in a property file so that it's not just the private neighbors. It would also be the township that would be reviewing it to issue a permit approval.
I understand that clarification, but it would also not be the first time a township or a municipal body misses a recorded, any kind of recorded instrument, right? But thank you for allowing me to express my concerns.
If Dan is still here in 100 years, though, he better be doing it.
1K is going to be huge by then.
Richard Van Horn, 584 HEACOCK Road. One thing I didn't recall us talking about is traffic on that road. You having a neighborhood coming out across the street. Is that driveway going to be straight across from there or on an angle? I live on that road and I struggle a lot now getting out of my driveway. And I see accidents and lots of things happening right there. And I'm wondering how you would address that traffic, or are we going to be witnessing problems going forward?
Yeah, we've actually had the traffic engineers work with PennDOT, meeting at the site, and the permit was issued. So the site distance is good, the traffic counts were suitable, and that driveway will be safe there.
Okay, thank you.
Thank you.
Paul, you already have a hat trick,
Yeah, Paul. One more thing, I guess. So the side yard, we're saying that's going to be like the pseudo backyard. And I know this is very similar to a lot of other properties in the area. Is there any other houses that you can talk about that have a side yard on the highway where like their kids would be playing? 'Cause I know that road is dangerous. You have all these people, and that's going to be where your kids play, on the side yard on the highway. So the property itself is very
Paul, how the property's used really isn't something that we have governance over.
something to think about, though. But I think like something to keep in mind. Okay.
Do I have 2/3 of a hat trick to use?
No, this is your hat trick. Everybody throw their hats. We got two guys who got hat tricks.
All right. So I guess I'm just confused as to why people are going through all these machinations to try and make this work. We don't owe these people anything, right? And they bought this property knowing what the restrictions were. I think it's going to change the character of the neighborhood. The setback is an egregious change from what the original calling was. It went from 100 feet down to less than 20 feet. That's an 80% reduction in a setback that somebody thought was important in terms of maintaining the character of our area. And I just don't understand why we're striving so hard to find a compromise to make this work. It's an easy call.
Well, first of all, we haven't had a vote. So I don't know.
understand,
I don't
but
know.
You're indicating that you're going to go for it.
I am going to go
Well, that's
for
why
it.
I'm- that's
So
what I'm saying.
if you're asking me directly, I can
No, I'm
answer
not.
that.
I'm
I
just
mean, I
saying
can
as a
answer
general
your
comment.
question. I'll answer your question.
Go ahead.
So we have a lot that is wildly non-conforming relative to the neighborhood, right? So now we're talking about we're going to have an improved property that doesn't conform. We already have a property that doesn't conform, and that's why we're all sitting here, because we have a property that realistically that doesn't have the opportunity to be developed. I don't advocate for applicants ever. So I'm not here advocating for applicants. I'm looking out, trying to figure out what's a fair compromise, if we have a fair compromise. Last time, we didn't have a fair compromise. You understand? I led
But I don't understand why you're striving for a compromise. A woodland.
because I know, because I've been in real estate my whole life, and I know that ranch house isn't going to negatively impact your neighborhood. I know that.
Well, it's not going to add to my neighborhood, I can tell you that.
They
And
might be the
also, you're
nicest
gonna-
people
you're
in
gonna be
America.
let me finish. You're getting rid of woodland, you're getting rid of natural habitat for no good reason. For no good reason.
Listen, you asked me. I mean, I was
giving you my opinion.
No, that's
My
fair.
opinion is you're not doing anything to improve anything. You're detracting from our neighborhood and from our community by trying to help somebody make money who's not even a resident. He's a developer. Why do you care?
I just gave you my point of view.
Okay. I don't get it, but thank you for that.
So everybody knows my point of view. Anybody want to add anything on the board?
So we're sitting here looking at a property that's been undeveloped forever, right? And I think we're seeing a lot of reasons why it's undeveloped. Someone said earlier that not everything should be developed around here. This is a little postage stamp that, I mean, you could put a birdhouse in the middle of it and it doesn't conform. I don't think anything should be built there, and I think the township should consider purchasing this.
Hey, welcome to the board, Dan.
I don't know that I'm allowed to answer that based on advice of solicitor, but we are open to open space as the referendum was last year. I'll just say that.
All right. At this point, would someone like to make a motion?
I'm going to butcher this, but I'd like to make a motion to approve the variance for the proposed setbacks with the deed restriction of only allowing a ranch to be constructed.
James, let me interrupt you. Mr. McGinnis, can you and your client discuss what you feel is a reasonable height for a ranch property he plans on developing there, so we can put that in the deed restriction?
Thank you.
Like 18 feet, no higher than 18 feet.
Well, board, we need to discuss that. Is 18 feet, it's basically almost, it's a little over half of what's allowed, which is 35 feet. Does 18 feet seem reasonable to this board?
It does. You have to have a couple feet for the theoretically foundation above grade. You have your framing for the first floor. You have 8-foot minimum height to the ceiling, and then you're going to have your roof trusses. So 18 feet makes sense.
Yeah, we need some pitch to the roof.
Yeah.
So there's shingles up there, not a rolled roof. All right, James, can you start over and work in the fact that the ranch-style house with a maximum height of 18 feet, please?
And the other deed restriction too on the rear lot.
Yeah, basically that behind the improvement, behind the ranch home in the rear yard, no deed restriction for no future improvements.
All right, I'd like to make a motion.
Oh, and lastly, the applicant said that he would plant a row of arborvitaes along the rear property line. Was that part of your application? I don't see it in there.
It's in, I don't think it's part of the application, it's on Vince's plan. We're willing to agree to that. That can be recorded as well against the property, with the township having enforcement rights for maintenance purposes.
Okay, so there's a lot going on here, James. So work through it slowly, and we'll get to the end of it. Did Mr. McGinnis, can you reword how you said that again? You agreed to
a row of arborvitaes to the township's satisfaction that could be planted and maintained in perpetuity, that would be recorded against the property, with the township having enforcement rights for maintenance purposes, similar to if there was an improvement as part of a subdivision with common space, that the township would have enforcement
Basically,
rights for the improvements.
township would have enforcement over a maintenance agreement.
Correct.
All right. James, I swear, go with God. I wish you the best of luck.
All right. I'd like to make a motion to approve the proposal with a deed restriction of allowing for a ranch no higher in height than 18 feet, the relief of the front and rear setback, and then also a deed restriction limiting or not allowing for any further development in the side yard.
Rear yard.
Rear yard.
Rear yard.
James.
Rear yard. And then also a row of arborvitaes would have to be planted, allowing for not just township approval, but also to ensure that they're maintained in perpetuity.
So Adam, you heard it. Is that something you can write a decision on?
Yes, and deed restrictions will be, well, kind of implies recorded, but they will be recorded. So deed restriction of 18 feet max, no development in the rear of the property, and a row of arborvitae along the rear property line with township oversight and enforcement powers.
Would someone like to second it?
I'll second.
Discussion amongst the board. All those in favor? Aye.
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 All those opposed?
Aye.
Let it be noted that the variance was approved 3-2. Thank you, everybody in the audience, for coming up and making your points. Thanks for your patience. And I'm sorry you didn't get exactly what you wanted.
Thank you.
Thank you, Board.
Mr. Elrod, you stick around? All right. We still haven't adjourned the meeting, so
We have how many do we have for the 20th?
There's currently 4 scheduled for the 20th. 1 continuance and 3 new ones.
So 4 scheduled for the 20th. Anything else down the road we need to know about?
No, obviously the 1675 Yardley Langhorne one got postponed to the 17th of February. There'll probably be a handful on that meeting as well, and potentially might need to have its second meeting February 3rd.
All right. Anything huge coming up?
So on the 20th, there are 2 homes in floodplains. One is continued, that got continued, it's for 194 River Road. The other one is for a house on Manor Lane. And then St. Ignatius Church is requesting a use variance to put an electronic message center on an existing sign. And then the 4th one is an impervious surface.
All right. Can
Maureen will be here.
Can you see if you can get an alternate for me for that hearing, since I'm a St. Ignatius parishioner?
Sure, I can.
I'm going to have to recuse myself.
Do I have to recuse myself too?
Are you active? Then you probably should recuse yourself, yeah. Paul, I'll be right with you in a minute.
If we have, yeah, I'm just trying to think with our current board. I mean, if Mike is back, because we won't have the ability to have anyone new appointed before the 20th. So if we have Mike, Peter, and Christian, that'll be 3
So you just, they just recuse themselves from that one.
from that
Yeah,
one.
Correct.
Yeah, so as long as we have Mike here and
All right, so they.
Then we should be fine.
They can
Yeah,
go
because-
to a vote with 3.
yeah, because we don't want,
Okay.
4 is not going to be helpful.
All right, anything else, board? Anyone want to make a motion to adjourn?
So moved.
All those in favor?
Aye.
Aye.